I am Professor Ashok Kotangle. I am an advocate, High Court, and I practice in the Supreme Court also. I would like to say few words about Indian Evidence Act. Before passing the Evidence Act, the principle of English law of evidence were followed by the courts in India. Main object of law of evidence is to assist the court in judging what facts are relevant to ascertain the courts by lawfully leading the evidence. In 1868, Mr. Maine, means that is how do we spell it? Maine, afterwards Sir Henry Summer, prepared a draft bill of the law of evidence. However, it was abandoned. In 1871, Mr. Stephen, he is known as Sir Henry Fitz James, prepared a new draft which was passed an Act of 1 of 1872. Law of evidence is a lex fori. Lex fori means the law of place of action. The main principle of law of evidence are: evidence must be confined to the matter in issue. Hearsay evidence must not be admitted. Best evidence must be given to all cases. Law of evidence deal with modes of leading evidence as well as regulating that evidence of which fact can be given to in a court. The main object of law of evidence is to assist the court in judging what facts are relevant to ascertain the courts by lawfully leading the evidence. The corpus juris, that is the body of laws, is divided into two categories, that is subjective law and adjective law. Law of evidence is a law of procedure, that is called adjective law. Evidence Act does not define rights or liabilities under the law, but it only prescribes the modes by which rights or liabilities of a parties is as curtained. Therefore, it is adjective law and helps in implementing the subjective law. The Indian Evidence Act 1872 mainly based on the English law of evidence. The Act consolidates and defines and amends the law of evidence. The law of evidence is not just a fundamental principle governing the process of proof. Rather, it also has a multi-dimensional purpose of governing the rules relating to the process of proof in a court proceedings. The extent and applicability of the law of evidence. Now, Section 1 of the Evidence Act 1872 speaks about the short title, extent and commencement. This section says that the Indian Evidence Act of 1872 came into force on 1st September 1872. It applies to whole of India, including the territory of Jammu and Kashmir. It applies to all judicial proceedings in or before the court, including court-martials under the Army Act of 1950, the Navy Act of 1957 and the Air Force Act of 1950. The term judicial proceeding is defined under this act. However, it had been held by the Justice Spanky in the case of R versus Golem, that is decided in 1875, ILR 1. All that judicial proceedings can be expressed as any procedure over the course of which evidence is or might be taken, or in which any judgment, sentence, or a final order is passed down recorded evidence. The court has to perform administrative or executive and legal obligation all together, so that in a judicial proceeding the adjudicator or the magistrate must act in a judicial capacity. It had been held in the case of Munnalal versus State of UP, AIR 1991, 1893, Criminal Law Journal 1991. That is, a family court also falls inside the ambit of the significance and articulation of a court. The affidavit presented to any court or officer, or a proceeding before an arbitrator, or proceeding before the court martial convened under the Army Act, the Naval Discipline Act, the Indian Navy Discipline Act, or Air Force Act. Departmental inquiries. The affidavit presented to any court or officer, or a proceeding before an arbitrator, or proceeding before the court martial convened under the Army Act, the Naval Discipline Act, the Indian Navy Discipline Act, or Air Force Act. Departmental inquiries, domestic inquiries, or commission of inquiries, contempt of court, tribunals, and the labor court. Now there is a certain provisions are repealed and enactment. Now section 2 subsection 1 repealed all rules of evidence which were not contained in any statute, act, or regulation in force in any part of British India before passing of the Indian Evidence Act. The rules of evidence were governed by the rules of equity, justice, and good conscience. Section 2(1) repealed all those rules of evidence. The Repealing Act of 1938 has repealed Section 2 and Schedule. Now come to definition of fact, relevant fact in issue, and document and evidence. Now Section 3 of Evidence Act of 1872 defines fact as: the fact means and includes anything, state of things, or relation of a things capable of being perceived by the senses, any mental condition of which any person is conscious. Now what the relevant fact means? Relevant fact means one fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of the Indian Evidence Act relating to the relevancy of the fact. The word relevant has two meanings. In one sense, it means connected, and another sense, admissible. One fact is said to be relevant to another when the one fact is connected with the other in any of the way referred to in the provisions of the Evidence Act relating to relevancy of the fact under section 5 to 55. Logical relevancy means a fact is said to be logically relevant to another when, by application of our logic, if it appears that one fact has a bearing upon another. Legal relevancy means a fact is said to be legally relevant when it is expressed as relevant under section 5 to 55. Now come to fact in issue. Fact in issue is defined under section 3. The expression fact in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows, whether under the provisions of the law for the time being in force relating to civil procedure, any court records an issue of a fact, the fact to be asserted or denied in the answer to such issue is a fact in issue. Now, such fact is required to be proved. So, what do you mean by proved? A fact is said to be proved when, after considering the matter before it, the court either believes it to exist or consider its existence so probable that burden man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Now, coming to the disproved. A fact is said to be disproved when, after considering the matter before it, the court either believes it that it does not exist or consider it non-existent, so probable that prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. Now, coming to not proved. A fact is said to be proved when it is neither proved or nor disproved. A fact is said to be not proved when neither its existence nor its non-existence is proved. In other words, the man of ordinary prudence neither believes that the fact exists nor he believes that the fact does not exist. Now, coming to the documents. A document means any matter expressed or described upon any substance by means of a letter, figure, or a mark, or by more than one of those means intended to be used, or which may be used for the purpose of recording that matter. Now, coming to evidence. Evidence means evidence is something which is used to prove or disprove a fact. Evidence itself a fact. Evidence is classified as under oral evidence and documentary evidence. However, under some legal system, there is a third type of evidence which is called a real evidence, which is not recognized under the Indian Evidence Act. Real evidence is in the form of objects which are covered under the documentary evidence. Now, coming to the kind of evidence. Direct evidence and indirect evidence. Now, direct evidence means the evidence given by the witness who saw or heard or perceived the fact in issue or relevant fact. Under this, the evidence is given by the witnesses on the basis of his own perception. For instance, eyewitnesses. Direct evidence is considered as the best form of evidence, best form of oral evidence of the fact to be proved. Now, coming to indirect or a circumstantial evidence. Indirect or a circumstantial evidence means indirect or circumstantial evidence are which attempts to prove the fact in issue by proving other facts. They do not provide a definite proof, but gives general idea as to existence or non-existence of the fact in dispute. Now, coming to the kinds of evidence. The kinds of evidence are hearsay evidence. It is the evidence given by witnesses who derived it from those persons who saw it. It is one which witness neither personally seen or perceived it through his senses, but has come to his knowledge from other person. It comes under the weaker category of evidence. The Act lays down that hearsay evidence must always be excluded. However, there are few occasions where it is admissible.